House Bill 370, the bill being enacted to require compliance with immigration standards and administrative laws. Judge, so moved by name.
Gentleman from Caldwell, Representative Hall, is recognized for motion.
Mr. Speaker, I move that the House do concur with the Senate Committee substitute of House Bill 370.
The gentleman has moved that the House concur with the Senate Committee substitute to House Bill 370, and the gentleman has the floor to debate the motion.
Thank you, Mr. Speaker. Colleagues, as you must be aware by now, there are a small number of sheriffs in North Carolina who have decided to stop cooperating and in many cases stop even communicating with federal immigration authorities regarding illegal aliens who have been charged with crimes in our state. The effect of these policies has been to allow dangerous people onto our streets. Just last week in Mecklenburg County, we saw an example of that, where an illegal alien who had been charged with first-degree rape, 2 counts of indecent liberties with a child, was allowed to be released when the Mecklenburg sheriff refused to honor an ICE detainer or even notify ICE of the individual's release. Didn't even pick up the phone and say, hey, this individual was charged with serious crimes. We know there's an ICE detainer. We're going to release it. Didn't even do that. Oh. Of course, this person had also been previously deported in 2006. And then in May, as you probably saw and was widely reported, another illegal immigrant who had been previously deported was charged with assault of a female, communicating threats, felony larceny, and other charges. Yet he was allowed to walk out of the Mecklenburg County Jail one day after ICE had issued a detainer request to the Mecklenburg County Sheriff. And then 1 week later, the same person was arrested again after a 9-hour standoff with law enforcement. This time he'd been charged with domestic violence against the same victim as the first time. Assault by strangulation, kidnapping, assault of a female, communicating threats, and violation of the domestic violence protective order. The bill before you today would put a stop to these policies in North Carolina. And the important thing to understand as we debate this bill is that it only applies to illegal immigrants who have been charged with crimes in North Carolina. Period. It codifies what almost every sheriff in the state is already doing. And that's why the North Carolina Sheriff's Association has endorsed this bill with what they call high priority. Because they know what we do. And that is the sheriff's job is to do everything that they possibly can to protect the citizens in their community. We work with the Sheriff's Association and any sheriff that wanted to work with us. And so when the bill went to the Senate, we made a few changes. We heard over here that one concern some of these sheriffs had was that they wanted a judicial order. So we made a change to give them a judicial order. Essentially, this bill requires the sheriff, again, when somebody's been charged with a crime, they check their immigration status. If ICE says this person is a legal alien and there's a detainer outstanding, the sheriff has to take that person before a magistrate, a third-party judicial official. And then that magistrate must put in that person's pretrial conditions of release that the ICE detainer be honored. So we've addressed that concern. We've addressed the concern of having a neutral third-party judicial official make this determination. The other thing that's important to understand before you vote on this bill today is that ICE has a job to do under federal law. This bill doesn't exist in a vacuum, and frankly, whether we pass this bill or not, ICE is going to continue to do their job. But what they've done in the past, before a few sheriffs decided they were no longer going to cooperate with them, is they mainly focused on jails. They would focus on the criminal element of the illegal immigrant community. Not going out into communities necessarily, but focusing on jails. And of course, since these policies were implemented, we've seen the result. ICE has to go out into neighborhoods and into workplaces because they've got a duty under federal law. We are a nation of laws. We're a nation with a border, despite what some may wish. And ICE is going to continue to enforce those laws. They would like to do that inside the jail, in a controlled environment where they're targeting, again, the criminal element. But these sheriffs won't let them do that. And these sheriffs, in so doing, are putting partisan politics ahead of public safety. There's simply no way around that. I've heard people say that that this bill would hurt the relationship between the sheriff and the local immigrant communities. But the reality is, just like most people, those communities are not distinguishing between federal and state law enforcement officials. I've heard people say that the citizens of these counties voted for these sheriffs. Shouldn't we just allow that to stand? But the reality is, these sheriffs campaigned mostly on 287G, not the extreme policy that we've seen since then, and just simply not even communicating with ICE at all. And even if that is what those folks in those counties want, that doesn't mean that the individuals being released are going to stay in those counties. They certainly don't respect national orders. How can we expect them to respect county orders? They're not. And so when the sheriff of Mecklenburg County or Wake County or whatever county it might be allows one of these individuals to leave, there's no guarantee that's where they're going to stay. And if you work in the court system much, you know that indeed they don't usually stay there. They're often never heard from again. And so when they're released from Mecklenburg, I don't know if they're going to come up to Caldwell County, Howard, Ward, and hurt my family. Some of you live around some of these counties where the sheriffs are refusing to cooperate with ICE. You can't guarantee that these individuals are not going to come to your county. And so that's why we've got to have this bill. And in closing, I want to read a quote to you from one of our presidents. Over the past 6 years, deportations of criminals are up 80%. And that's why we're going to keep focusing enforcement resources on actual threats to our security. That's not President Trump. That's not either the President Bush's. That's not President Reagan. That was President Barack Obama in November of 2014. And yet, just 5 years later, somehow, left-wing ideology dictates that we can't even deport illegal aliens who have been charged with crimes in our country. I would submit to you that if you're left with Barack Obama in North Carolina on the issue of illegal aliens being charged with crimes and being deported, you've probably gone too far. And if these sheriffs won't do all they can to protect the citizens of their county, they ought to resign. The citizens of this state deserve public safety. If these sheriffs won't give it to them, we will through this bill. I encourage your support. Thank you.
Bob Herbsley from Durham, representing the Morning Rights.
Thank you, Mr. Speaker.
Please recognize the debate bill for the motion.
Ladies and gentlemen, we heard the example in Mecklenburg County. That is an outlier of what we see in our courts. Over 54% of those that have been picked up on ICE detainment have been picked up for a traffic violation, and they have no prior criminal record. One case I will never forget when I was presiding in the jail on the first appearance was a lady who was charged with no operator's license. Her car had been in a minor offense. She was the victim. They took her in because she didn't have an operator's license. She lived here for over 25 years. She couldn't get one because she didn't have a birth certificate. Her 14-year-old daughter was in the backseat of her birthday. And at that time, we did notify ICE, and they did a hold on her. And that child never saw her mother again because she was accused of not having a driver's license. The vast majority of cases we're talking about are people with traffic violations that you're asking to be held, and people with no criminal records. The example in Mecklenburg County, what was the problem? Maybe the bond was too low. It wasn't about notifying ICE. That's a red herring. We asked our sheriffs, who are constitutionally elected, to keep our county safe, to patrol the streets, to do investigations, to serve domestic violence orders, to serve civil papers, to run and operate our jails. And now with this bill, we're also saying, why don't you take over a quasi-federal agency that has a $3 billion budget, and why don't you add to the duties we're already asking you to do? This is unnecessary. It is draconian. It will affect and rip apart families across the state. Sheriffs do their responsibility, keeping their communities safe. Let's have ICE take care of what ICE is obligated to take care of with immigration issues. But to pass this bill is going to result in many those charges. But once a person is made bond, and once a person has served their sentence, to then say, oh, let's add on a couple days. It's not just a couple days. It's having people deported on minor or traffic violations that have been in our communities for years and years. I urge you to vote no on this bill. Thank you.
For what purpose does the gentleman from Mecklenburg, Representative Alexander rise?
To debate the bill.
Gentleman has the floor.
Members, when Gary McFadden ran for sheriff of Mecklenburg County, he made it very clear what his position was on detainees. So I think the last time I looked, there were close to 80 folks in Mecklenburg. Everybody knew what his position was. He didn't hide it under the table. So it's no surprise as to the fact that he has stayed very steadfast in his position. Now, there's been a lot of talk about somebody who got out of jail and should have been held, some folks say, on the detainers. The only problem with that is that person had a bond, $100,000. And now, you know, as you know, I'm not a lawyer. I'm a humble undertaker. And I'm of the opinion, though, that once you pay that bond, the sheriff doesn't have any right to hold you in jail anymore. You're pretty much free to go. Now, again, even though I play a lawyer on TV from time to time, I'm not one. I was under the opinion that if you hold somebody like that, that you just may be violating their constitutional rights. And they have constitutional rights. And we have to be very careful about violating constitutional rights because that opens up something you lawyers call cause of action, I think. And that gets us into more and more litigation and gets us spending all kinds of money that we don't need to be spending around, these issues. Now, we did a little research, and Representative Archery can give you all the details that you need, but there's something that he said in discussing some research that just really stuck with me, and I want to share it with you. We have an immigration court down in Mecklenburg. And in that immigration court recently, they deported about 4,500 people. And when they investigated and looked at how many of those people were desperados, the kind of folks that everybody's always talking about, that you don't want in the country. People with felony convictions, bank robbers, criminals, that kind of folks. Of that 4,000, there were 8 that fell into that category. 8. This measure is overkill. We are demanding of sheriffs, and you're creating a situation in it that if a sheriff does not abide by this particular measure, that is prima facie evidence that the sheriff can be removed from office. Constitutional officer, voted on by the people of their county, can be removed from office because they do not comply with essentially a voluntary program that generates an unfunded mandate that nets out of every 4,000 deportees, maybe 8 desperados. This makes no sense. I urge you to vote against it.
For what purpose does the gentleman from Richmond, Representative Brewer, rise?
To speak to the motion.
The gentleman has the floor.
You know, part of what's lost in this is this program that we're trying to get the sheriffs to do is that it is a voluntary program. It is not a requirement under federal law. It is a voluntary program. And why it is voluntary is these warrants are issued by law enforcement officers and not a magistrate or a federal judge. There's not one sheriff in the state that would not honor this if it was signed by a magistrate or a judge. And I think it's important that we remember that. We are asking our sheriffs to lock people up on the word of a law enforcement officer. There's no other provision in our law that does that. I prosecuted for 15 years, sat on the bench for 16. If someone from another state has committed a crime, a law enforcement officer could not call North Carolina and say, hold John Smith for a few days, we'll get you a warrant that's signed by a judge. You have to get that warrant first. You have to take it to a judge here and get a fugitive warrant in this state. That's how we need to address this. We need to set this up through Chapter 15A as a fugitive warrant based on what the federal government is asking. All the ICE agents have to do instead of them signing it is walk down the hall to a magistrate or a United States District Court judge and get the warrant signed. I think this is going to potentially hold our sheriffs to violating the Fourth Amendment of the United States Constitution and under Article 1 of the North Carolina Constitution, Sections 19, 20, and 21. And Section
Just a moment. For what purpose does the gentleman call over to the hall rise?
See if Representative Brewer will yield for a question.
Representative, gentleman, yield for a question from Representative Hall?
Not at this time.
Doesn't.
I will shortly. Section 20 says, general warrants are dangerous to liberty and shall not be granted. Dangerous to liberty. This doesn't even qualify as a general warrant. So I don't know how any sheriff doing this under North Carolina law will be protected if there's a lawsuit. Think about this situation. If a sheriff went to take somebody's guns for 48 hours because they felt they were a danger to the community and kept those guns without a judicial official making any sort of determination, what would the reaction be? Somebody's liberty is just as important. And we need to respect that liberty because it's required under our constitutions, both in North Carolina and federally. We're locking people up without warrants. All you have to do is get the signature. It's not that hard. I've signed countless warrants over my time as a judge. Judge is pretty easy to find. ICE just has to want to go do it. And the reason I say all this is because of the removal part of Section 2. We're going to want to have a mechanism for removal for violating a specific offense in our state. Nowhere else, for no other office, does a violation of a specific offense warrant removal. And that's a problem for a lot of the sheriffs. I've got 3 sheriffs that have 3 different views, but the one thing they have in common is they don't like the removal provision of this statute. And removing them puts them in a terrible position. If this law is found to be unconstitutional in North Carolina, as it has been in other places, other communities have had to pay out legal fees for people being locked up under this. We're going to have the conundrum that sheriffs will face. If we lock someone up and it's found to be unconstitutional, they could face removal. If they don't lock someone up, they could face removal. It's a terrible position to put the sheriffs in until this is sorted out through the federal courts. Again, this is a voluntary program. It is not required. All they have to do is go down, get a warrant, just like we do from other states. I really think if we put this bill back in committee, get it into Chapter 15A, where if our local magistrates or judges use this as a determination of the conditions of release, we'll get to the result everybody wants in a way that is not going to end up with our sheriffs in court or this law being declared unconstitutional. And I'd be happy to yield to Representative Hall at this time.
Representative Hall, the gentleman has yielded to a question. If the gentleman still wishes to ask,
I do.
the gentleman does. The gentleman is recognized.
Thank you, Representative Brewer. Representative Brewer, I know you're aware of the individual in Mecklenburg County who I referenced earlier in my remarks, who was charged with first-degree rape and 2 counts of indecent liberties with a child, and who was allowed to leave the Mecklenburg County Jail. My question for you is, do you think that it was proper for the Mecklenburg Sheriff to release that individual rather than hold him on an ice detainer?
A magistrate or a judge of the state of North Carolina had set that individual's release. From what I understand about it, all I know is what I see in the newspaper. I'm not familiar with the details. But a magistrate or a judge had set those conditions of release. And in order to the sheriff of what those conditions were, the sheriff followed those orders of release to the letter. When that person posted the bond in accordance with what was set by a judge, the sheriff did what the sheriff should do, is follow the law and follow the order that he was given by a judge. The sheriff had no other choice at this point. What was sent by the federal government was not signed by a federal judge or a federal magistrate. That's all ICE has to do. It's not that hard.
Follow up, Mr. Speaker.
Representative Brewer here.
Absolutely.
Again, referencing the same individual in Mecklenburg County who was charged with first-degree rape and 2 counts of indecent liberties with a child. My question to you is, do you think that it was proper for the Mecklenburg County Sheriff to fail to even contact ICE to let them know that the individual was going to be released from the jail so that they can be outside to detain the individual?
I don't think it's our place to tell the sheriffs who are constitutionally elected officers, just like we are, on what they should do on a voluntary program. If this was a required program, I would share your outrage for this. If they disregarded a federal judge's order or a federal magistrate's lawful order, I would agree with you 100%, but that is not the case here.
For what purpose does the gentleman from Pender, Representative Smith, rise? To debate the motion. Gentleman has the floor.
Thank you, Mr. Speaker. If a person violating the law by being in this country illegally is also wanted for ICE for other violations of the law, and then breaks yet another law in the neighborhood you and your family live in, it's past time for them to go. The sheriff should not open the door to the jail and allow them to walk out on your streets knowing ICE has placed a detainer on them for a legal deportation hearing. Those released may hang around, may go to another part of the state, they're still wanted by the federal government. And in some cases, as we know, they do violate the law. If you're in a county jail and you are wanted on a violation of federal law by our U.S. government, you can bet your sweet bottom you'll be turned over as soon as you meet the local release requirements. Why then wouldn't some sheriffs turn over a non-citizen? Why should they be let go for continuously violating the law? Why are the crimes of non-citizens overlooked? I believe that's just wrong. We've heard some opponents of the bill say the legislature should not tell elected sheriffs what to do. As someone who served as an elected sheriff for 16 years, I can tell you the legislative branch of government made a whole lot of decisions for me. Through laws and administrative code, sheriffs are told what to do and how to do it all the time. There are constitutional, statutory, and judicial restraints on every aspect of a sheriff's duty. When it comes to jails, sheriffs are told how many square feet of cell space an inmate has to have. They're told how many times a day the jail officer, how many times an hour the jail officer has to check on the inmate. They're told at what temperature the food for breakfast and dinner has to be served. Why then can a sheriff not be required to comply with a lawful request of a temporary hold on an individual wanted under legal authority by our federal government? Most sheriffs already do. Of course, I love the office of sheriff. I believe it's one of the greatest institutions that's set forth in our state constitution. But as our founders intended, this executive office is checked and balanced by the other two branches, including us. This bill does not target people solely because they are in this country illegally, and it does not force sheriffs to participate in federal programs such as that 287G. It merely requires the sheriff to treat an illegal alien inmate the same as they would treat you if you were wanted by the federal government. It will help keep our families safe by keeping illegal alien criminals off our streets, just as we keep U.S. citizen criminals off our streets. It's just the right thing. I ask for your support.
For what purpose, Gentleman McNamara, representative Walter Rice.
Debate the bill.
The gentleman has the floor.
Thank you, Mr. Speaker. Ladies and gentlemen, I don't know why we feel like we have to compel sheriff's offices in North Carolina to participate in a voluntary program that everybody's been talking about. And I'm sitting here looking at the Homeland Security website, and currently in North Carolina, there are 4 counties, Cabarrus, Gaston, Henderson, and Nash, that are currently participating in 287G. So if it's such a compelling issue regarding the safety of citizens of North Carolina, why aren't there more counties participating? Then we have the current situation of immigration court in Charlotte, which is the only immigration court in North Carolina. And as of June 2019, as my colleague, Representative Alexander alluded, that there have been 4,244 cases. Of those cases, 4,182 have been ordered to be deported. And only 8 of those actually had criminal records or were deemed as national security threats. So I'm reminded of a quote by H.L. Mencken, a journalist who died in 1956, who said that the whole aim of practical politics is to keep the populace alarmed and hence clamorous to be led to safety by menacing it with an endless series of hobgoblins, all of them imaginable. Thank you.
For what purpose does the gentleman from Chatham, Representative Reeves, rise?
To debate the motion.
The gentleman has the floor.
Thank you, Mr. Speaker. And I've heard a lot of the debate. What I'd ask everybody in here voting to do, first of all, is to try to ramp it down a little bit and look at what it is that we're actually trying to accomplish and solve. I think what happens far too often in this chamber is we get these one words that kind of get on top of everything that's on the bill. And then suddenly what we're debating really turns out to be our feelings on a particular issue and not really what the bill is about. I would ask that you vote against the bill, not because of, I think the quote that I heard earlier was a left-wing ideology. Though I do appreciate being continually stereotyping and grouped, I just say in this particular case, I actually have the ability to sometimes separate my own thoughts away from the groups that I get thrown into each time. Even though it's a lot of fun, I just want to tell you that. But what I would say is that it's possible to disagree with this bill without being a left-wing ideologue. It's possible to vote for this bill without being a right-wing fill-in-the-blank because I won't, because then somebody like taping me will say that I called all Republicans this or that. So, again, let's stop with the ideologies. Look at what the bill does. For the first time in 100 years, we're amending the removal statute. Now, I do like the fact that I've heard us discuss that we want to make sure that elected officials are doing their jobs and we want to be held more accountable. What I haven't seen in this bill is a removal statute for anybody in the General Assembly. And so I kind of struggle that the sheriffs now have the ability to be removed by simply someone coming in saying that they have not complied completely with the law. And I want you to think about that. Think about that in our positions. We try. I believe all of us try our best to comply with what we've been asked to do. But at times we may fall short. So the question is, do we feel good about a citizen coming in, filing a complaint, and then a judge saying, well, look, you didn't follow on this particular date. 364 days that year, you did a pretty darn good job. But on that 365th day, with no malice, with no bad intent, you did violate this, and so now you got to be removed from office, ignoring what the thousands of people in your county who voted for you felt about you. We spent a lot of days up here trying to legislate Mecklenburg County. And in all due respect to all my friends from Mecklenburg, Mecklenburg can't legislate Mecklenburg County. But I've spent every year that I've been in office up here trying to legislate a local decision of Mecklenburg County. And I just really think we got better things to do. I think if you don't like something that's going on in the county, then you talk to that county's residents and they make a decision. Because in fairness, again, going back to us, because again, we're talking about elected officials, so I think it's good to compare it to us. How good would we feel if, let's say, somebody from Chapel Hill decided who was going to be representing Lincoln? We'd probably say, hey, wait a minute.
What purpose jump from Lincoln, represent the same rise?
Ask the gentleman Hill for a question. I will for you.
I was gonna say, when you invoke the county, you kind of walk into the
I thank the gentleman for yielding, and I find it incredibly interesting his example that someone from Chapel Hill was trying to come into Lincoln County and pick who would represent Lincoln County, because best I can tell last election, that's exactly what happened. So I appreciate the gentleman giving me the opportunity to bring that up to people in this body.
That's pretty good. I didn't know anybody from Chapel Hill was voting in Lincoln County, so thank you for the correction. So bad Chapel Hill. Back to my original point. The bottom line is this: voters can vote for who they want to vote for. They can ask for their laws to be enforced like they want to be enforced. They can ask for their sheriffs to try to enforce the laws to the best of their ability. But let me tell you what the General Assembly is not going to do. We're not going to provide more funds. We're not going to provide more support. We're not going to provide more bodies, but we're going to continue to tell them what they should or shouldn't be doing in their offices. This isn't about immigration. This is about the decision that we don't like something that one sheriff out of 100 counties did. And I think that's up to that county to make a decision if that's how they want the laws enforced. But law enforcement and immigration are incredibly complicated issues. And I would just say, when we vote today, remember what it is that we're telling people and what we're asking people to do. Secondly, one big issue that was coming up with this bill when it first came through has still not been addressed. What do we do about victims of crimes in these communities? Because what this bill is going to do is sentence them to no ability to have law enforcement. None. When they are victims of domestic violence, they have nobody to report to, because that sheriff now has to think about whether or not he's going to lose his job if he finds somebody undocumented who has been the victim of a crime and he doesn't go report them to ICE immediately. So do we want to condemn whole communities, whole families, to the ability in this country not to have the protections of our law enforcement? And I'm hoping everybody's answer to that is no, we don't want to have that happen, which still doesn't address that. And what happens when we do this is this doesn't stay a problem in a community of just people that you're thinking that you shouldn't consider. This goes throughout the communities. This goes throughout families. And we're not protecting them, and that's our job. So again, as we said earlier, Representative Alexander, Representative Brewer, the problem with the bill is that it's just a simple overreach for a problem that I'm not even real sure we ought to get involved in. Because according to everybody's statement, all of our sheriffs are doing what we want them to do. So just about all of the sheriffs are doing what we want them to do. Why are we trying to pass a bill that changes everything about how we approach this issue for maybe 2 or 3 sheriffs? And again, that's our interpretation about whether or not they're doing their jobs. With all due respect to the people who have talked about the one incident in Charlotte, I'm just like Judge Brewer. I've been in criminal defense and criminal prosecution and law enforcement for a long time. There's a whole lot more to that story. And it's not just that simple. And there are so many levels that have to be addressed before you start getting to whether or not there was an ICE detainer, how it was enforced, and things of that sort. So what I'm asking you to do is try to separate out your feelings. Try to stop figuring out what line you're supposed to be on based on the letter behind your name, your political party, what you've heard from people who actually don't understand what this bill is doing. Look at what the bill is doing and saying, are we truly, one, in an arena that we need to address? Two, if we are in an arena that we're supposed to address, is this the way to address it? And for me, just what it does to domestic violence victims, just what it does to crime victims of any sort, and just the sheriff's removal will be enough by itself for you to vote no. Again, if you want to address this, there are 100 other ways to address it, and I believe in letting the voters do that with our sheriffs, because their jobs are tough enough without us sitting on their shoulders telling them how to do it. Thank you.
For what purpose does the lady from Mecklenburg represent Cunningham rise?
Thank you, Mr. Speaker. I would like to pose two questions, possibly to Representative Smith or Representative Hall.
Which member do you want to address?
I can take Hall.
Representative Hall, the gentleman yield. It sounds a little like a shout right there, but he yields to whatever that was.
Thank you, Mr. Speaker. The question is, was there a physical note attached to this bill?
Thank you for the question. The answer to that question is no, because there's no fiscal impact. Nearly every sheriff in the state is already doing this. In fact, prior to December of 2018, all sheriffs were in some way cooperating with ICE. And again, I'll remind the representative that the North Carolina Sheriff's Association has endorsed this bill, high priority. They have no concerns about the cost, so we don't have it.
Thank you. I would like to speak to the motion.
Please recognize the main question.
Thank you for that, Representative Hall. Only 4 counties right now are enacting the 287G. And from my understanding, if we do it, it's a voluntary program, it's not mandated. Each time one of the individuals come into the jail facility, then there's a cost incurred. Just like if you have someone on suicide watch, the deputy or whoever assigned has to go check that individual every 30 minutes. That's a cost. So it's no reimbursement from the federal level to any of these sheriffs that are operating under 287G. So they're providing additional services. So there has to be some type of incurred expense. Thank you.
For what purpose the lady from Surrey, Representative Stevens, right?
It's been a couple of times I've heard, it's quite important.
Just take a moment.
A couple of times people have been talking about 287G, and have I missed something? Is 287G in this bill?
Well, it probably would be a point of order. It could be a question. The chair is under the opinion that the 287G is not referenced in the bill, but that would be a question. Or I would say more topic of debate. For what purpose does the lady from Guilford, Representative Harrison, rise?
To debate the motion.
The lady has floor to debate the motion.
Thank you, Mr. Speaker, ladies and gentlemen of the House. I don't want to repeat everything that's been said over this. On our side of the aisle, share all those concerns and more. We had a very healthy debate in judiciary, I think it was back in March, and I don't want to repeat myself too much for those of you who weren't there for the debate. It's worth pointing out that we had a list of more than 21 organizations that were opposed to this bill. In addition to the 6 sheriffs from White, Mecklenburg, Durham, Guilford, Forsyth, and Buncombe, there are a number of organizations that are concerned about the issue that Representative Reeves brought up about victims, including the Justice Center, NC Child, NC Coalition Against Domestic Violence, NC Coalition Against Sexual Assault, NC Victims Assistance Network. They're all opposed to this bill, and they're opposed to it because of what Representative Reeves said. This undermines law enforcement's ability to keep our communities safe, and it will discourage witnesses from coming forward and will result in actually more crime in those immigrant communities. And for that reason alone, it's enough to be opposed to this bill. And that's why our law enforcement is opposed to this bill, and that's why the law enforcement in these other large counties that deal with these communities. For reasons unconstitutional, that cost our local government, the impact on these victims, the fact that those who are sworn to enforce the law don't think this is a good move, I urge you to vote no. Thank you.
For what purpose does the lady from Wake, Representative Holly, rise?
speak on the bill.
Please recognize.
I don't want to duplicate a lot of the people on, that spoken here today. But I want to bring attention, I've talked a lot about safety, and I'm very, very secure in knowing that our sheriffs work every day. But I have a concern about how you're going to implement this bill and the personal impact that we're having on people and their families, and the discretion that is required in which to do so. For an example, I'm a person who looks like I could be a number of different things. And I go to every time I go to the airport, I get twisted. I have to say that I am racially profiled a lot, in a lot of different ways. I know that when I go to the hospital, I don't want them to say, do you have insurance if I'm critically ill? And if I don't have insurance, then say, well, I can't take you. I want the doctor to do what he can to save my life. I don't want our police to go and say, are you a citizen? Because if you aren't a citizen, I'm not going to protect you. Our sheriffs spend a lot of time protecting all the citizens that they're responsible for protecting. They police when it's necessary. Some of them, I think, over-police in a lot of ways. But I do believe that we need to look at this from a personal standpoint. To hold somebody for 48 hours because you can't get a driver's license for identification or verification of who they are. How are you going to discern who to hold and who not to hold without doing some kind of profiling? So we need to be very careful how we implement these bills. But I want our police and our sheriffs to protect all the citizens, and let ICE do its job, and not let our police departments get bogged down in paperwork, in jail time, because it is an expense. You got to feed them, especially if you're going to hold all these people for 48 hours. That's 2 days of feeding them, housing them, and the staffing that's required to do that. So all I say is, let's look at the personal aspect and be very careful when you make these decisions, because I don't want to infringe wrongly on anybody's personal freedom. Thank you.
For what purpose does the gentleman from Cyphers and Montgomery rise?
Speak to the motion.
Gentleman, rise.
Colleagues, I rise in this moment to hopefully bring light to another challenge with the bill that exists. In particular, I have no disagreement with what's been stated in reference to the fact that I don't believe that anyone in this chamber wants individuals who have committed a crime not to face the justice that they need to face. The question is, how do we follow the Constitution as it is currently written and as we all have sworn to uphold? The challenge is that what this does is we have a challenge on two particular areas. One, a detainer is not, as it's been stated by Representative Brewer, it is not a warrant. A detainer is simply a request from an agency to hold an individual. That is all it is. It is a request that they be held. It is not a warrant that simply says that this person should be held based upon what a judge has stated. And based upon what Supreme Court Justice Anthony Scalia stated very clearly that illegal aliens, in his words, have the right to constitutional protections in federal immigration proceedings. That is what he stated in his own words. And the reason that that matters is that if a person has committed a crime, we want to make sure that they face justice. The challenge is that many individuals who don't face justice are able to use the fact that they have not been given due process in order to not face the justice that they should face. And so what I'm saying to us today is that if we pass this as it stands, you are actually being counterintuitive for what you just say that you want to do. And that is to make sure that individuals who are criminals in our communities face justice. And that's not what we're giving them today.
What purpose, gentleman from White, Representative Jackson rise?
Yes, Representative Smith.
Representative Smith, do you have a question? Representative Carson Smith.
I do.
You have floor, please.
I believe you were a sheriff for a long period of time down in Tender County. And I heard Representative Hall say nothing was going to change. The sheriffs were already doing this prior to last December. And I just asked you, when you were sheriff, entertaining ICE detainers, did you ever, prior to the prisoner's release and after receipt of the detainer and administrative warrant, take the prisoner without unnecessary delay before a state judicial official who was provided with the detainer and administrative warrant or copy thereof? Did you do that in your office?
You have answered this one.
Or did I do what this law was going to require me to pass it? No, it was not law. If there was somebody, an inmate in the jail, I had a release order that was signed by a North Carolina magistrate or signed by a judge that told me, the sheriff, what the terms were for this person to be released. It may be putting up a cash bond. It may be a certain time they have to stay in jail. So with that release order, that's what I abided by. That's what this is actually setting up for the situations we're talking about here. If you have someone who is here illegally, broken law, ICE wants them, ICE has a detainer, then the sheriff, after this is passed, will take them to the magistrate and get the release order, giving them the ability to hold them up to 48 hours.
Gonna follow?
Yes, ma'am.
You yield?
I do.
You proceed.
And you would agree with me that that has taken an additional step by some sheriffs that they're not currently taking now, and that you, in a lot of jails in this state, you have to transfer the prisoner over to the magistrate's office to do this process. Is that correct?
Every town is different. I can tell you in my county, the magistrate's office was in the jail. So it was basically, you may have had to bring them from the cell to the magistrate, get the paper, if this passes, get the additional release order, and then they would be there for 48 hours until ICE had a chance to come pick them up.
Got an additional follow-up? Do you still yield?
I do.
Did ICE always pick the prisoners up, or the chargees, whatever you want to refer to them as, within the 48-hour period?
I did not have a whole lot in Denver. There were sometimes they did, and sometimes they didn't. If they were not there, then we did release it, because 48 hours is what they asked.
Have an additional question? You
I did.
see him?
If someone had been charged with child rape and assault and was a danger to the community, and there was an ICE detainer issued for that person, would it matter if ICE came and picked the person up in 48 hours? Wouldn't on hour 49 they still be a danger to the community?
But number one, if they were charged with something that serious and they were able to get released on the local confinement procedures, we got a problem locally. But I assume your question is, if this person were here illegally, wanted by ICE, they committed those awful crimes, and then somehow or another they were able to get out on the local requirements, then, and I think I don't understand the question. Madam Speaker,
Would
do
you like
you
to?
to restate the question, and I'll finish the
Would
answer.
you like to restate the question?
I can shorten it down a little bit, Representative Smith, and I have no problem if you want to yield to one of your other responses. That's it. I just don't know what's magic about 48 hours. Why not 49 hours? Why not 72 hours? Or if these people are such a danger to our community, why don't we just hold them until ICE gets around to picking them up once they've had this? Because under your deal, there's going to be a new order that by a magistrate that's going to say they're going to be held in additional. I just don't understand why. Where's 48 hours?
Madam Speaker, may I answer the first part and then yield to Representative Hall?
Representative Smith, you wish to answer?
Oh,
You may proceed. Representative Jackson, you wish to propound a question to Representative Hall? Representative Hall, do you wish to?
Thank you, Madam Speaker. I'll try to answer your question as best I can, Representative Jackson. The answer to that is that an ICE detainer is only good for 48 hours. That is the regulation from the federal government. That's the direction from the local sheriff. And the reason why, and I've spoken to the director of ICE for our region, they basically have a 100% rate within 48 hours. In fact, they usually pick an individual up in almost 90% of cases within 8 hours of being notified that the individual is in custody. And ultimately, it comes down to a question of federal law. And the federal law says to various cases, including the Arizona case, that local officials can do things at the direction of federal officials. And in this instance, ICE detainers are good for 48 hours, and that's why that time frame is on there.
Representative Jackson, do you wish additional follow-up?
Additional question, Representative Hall.
Representative Hall, do you yield for additional questions?
Sure.
May respond.
Representative Hall, are you aware of courts across the United States that have awarded damages, civil damages to people as a result of these ICE detainers?
I'm not aware of any courts that have any jurisdiction in North Carolina that have in any way invalidated ICE detainers. And in fact, most courts have not done so. It's only a small number of courts who have done that. And again, we can't lose sight of the fact that almost every sheriff in this state already cooperates with ICE detainers. And in fact, almost every sheriff in this country almost does that.
Representative Jackson, do you have additional questions?
I do.
Do you yield, Representative Hall?
I yield.
Representative Hall, are you aware of cases throughout the United States of America where U.S. citizens have been wrongfully detained under these ICE detainers?
The reality is, in any law enforcement situation, there's no perfection. However, ICE does a pretty good job overall, considering what they have to work with, including one of the major parties in this country trying to defund them. So I'd say they're doing a pretty good job.
Additional question?
Representative Hall, do you yield?
Absolutely.
On page 2 of your bill, line 18, it says, no state or lawful law enforcement office or agency shall have criminal or civil liability for any action taken pursuant to an order issued under this section. You would agree with me that these officers and agencies are still in fact liable under federal law to be sued in federal court under section 1981 civil rights actions, would you not?
Well, I'm going to ask you to clarify your question, and I'm going to try to answer what I think your question is, and then you can clarify if I'm not answering that. No, under 1983, there's going to be no liability for honoring an ICE detainer. If that's the case, every sheriff in this state, or at least 90 or more, are going to have a real problem.
Representative Jackson. Representative Hall, do you continue to yield? I thought you could say that.
Why would I say that?
So we should be done.
I did.
Representative Jackson, your final question.
Is it your understanding that in fact there have not been civil judgments against sheriffs across this country for improper detainer orders that were recognized by the sheriffs? Inmates were held, and inmates were awarded 1983 damages. Is your understanding that's never happened?
No, that's not what I said at all in my answer. What I said is my understanding, and it's not only my understanding, in fact, this is the case. That's never happened in North Carolina. No federal court that has any jurisdiction in North Carolina has ever decided that. And yes, I mean, there have been a small number of courts across this country who have made the decision that you're talking about. But the reality is, it's a very small number of courts.
Representative Jackson.
I believe he asked for Representative to yield to him. So if I could ask him differently.
Representative Hall,
Absolutely.
yield.
Okay, so I want to go back to the section that I was talking with Representative Smith back on page 2, starting on line 1. You said that sheriffs were already complying with these ICE detainers. But in fact, doesn't this bill now require something that even the sheriffs who were agreeing and complying with ICE, that they now have an additional step to take an inmate in front of a judicial officer for this 48-hour order?
Every law enforcement officer, when they arrest someone for a crime, must take that individual before a third-party judicial official, and typically that's a magistrate in our state. So that's already happening. In this instance, and again, this is trying to address some of the folks on the other side stated issues about the bill. We did add the requirement that when they bring them in, they find out there's an ICE detainer, then they'll take them back before the magistrate. In most counties, I would say, that is not an onerous thing at all to do. And as Representative Smith noted, in his county, the magistrate's office is actually just down the hall from the sheriff's office. And again, if that were going to be some issue for our sheriffs, I don't think that the North Carolina Sheriff's Association would endorse this bill with high priority. I trust the Sheriff's Association to tell me that that's not going to be something that's going to cost them a lot of money or cause them any problems. So I don't see it as being in any way an onerous extra step.
Representative Jackson, you have the floor to speak with.
So what you've heard is a lot of talking around the issue, but not really answering the question. So I'll just tell you, this envisioned a second trip to the magistrate judge, and maybe this is not a big deal in Federal County. It might not be that big, it may not be. Now, this bill does make a change so that now it's going to apply to all criminal offenses. So while Sheriff Smith was maybe doing this for all, and the past law was only being done for felonies and specific impaired driving offenses. Now it's going to be everything. So if somebody presents without a driver's license, no operator's license, they're going to be taken downtown, they're going to have to go in front of the magistrate. They're going to get an order of release, $500 bond, unsecured, whatever. ICE will be notified. They get a detainer back. That person now has to go back in front of the magistrate. So to say that this bill has no fiscal cost it's just unbelievable. Okay? Anybody who works in the courthouse knows that nothing happens without cost. And so now a sheriff's office in my county, it might be 100 inmates a day. In Mecklenburg County, it might be more than that. I don't know what it was. It was enough. It was enough inmates in Mecklenburg County that ICE rented an office in the jail because they had to be there so much doing all this. And so now you have to do this in front of the magistrate. The magistrate's going to see an extra 100 cases a day. To say that has no fiscal cost is just beyond. This was a bad deal the first time it came to us. The Senate took it. They made it a little better in some ways. They made it a little worse. It's still a bad idea. I ask you to vote no.
For purposes of the gentleman from Brunswick, Representative Fowler, rise.
To very briefly break the motion.
You have the floor to very briefly debate the motion.
Thank you, Madam Speaker. I want you to hear from a non-attorney a couple seconds. When debate gets far afield, sometimes I call that my most non-constitutional, take a look at it. And Article 7, Section 1 begins, and this is very brief, the General Assembly shall not may, provide for the organization and government and the fixing of boundaries of counties, organization and government, and fixing the boundaries of counties, cities, and towns, and other governmental subdivisions. And except as otherwise provided in this Constitution, may give such powers and duties to counties, cities, and towns, and other governmental subdivisions as it may deem advisable. So yes, in context of all what you heard, particularly referring to the sheriff, they are independently elected, but we have the obligation to help, to shall provide for the organization of government and fixing the boundaries of counties. So, context to everything you've heard, we do have an obligation to do what we're doing here and to protect the citizens. They're the citizens of the county, citizens that voted for that sheriff, and they're our citizens of this body of 120 here today. Thank you.
What purposes Representative from White, Representative Dowd,
To speak on the bill?
you have the floor to speak on the motion to concur.
I'll speak on the motion. So I have a concern, and I don't know if any of you have ever been through the immigration system, but my wife is an immigrant. And I've had the pleasure of our federal immigration system. It is a long and arduous process. It is not clear. We actually had to hire a lawyer to go through that service, and we're both college educated. I believe that we should be able to follow through. But one of the issues that nobody's really talking about is sometimes things get sent in the mail and not caught up in the computers. So this bill would actually have sent my now wife back to England when her green card didn't come for 3 weeks, because she would have then been an illegal, but she wasn't illegal because she was in process. And there could have been an ICE detainer put out on her because she was still in process. So this doesn't alleviate some of the issues. So if someone is legally here, but they're in process and the federal government hasn't caught up, then they would be sent home. So I'm really confused as how we're gonna handle that, because the federal system is a very slow system. I'm also concerned about victims. I'm concerned about men and women who who have crimes who have had crimes what's the word I'm looking for? Perpetrated against them. And then they don't get justice. So we're helping people circumvent our law. We're helping people get away from crimes. This is a real concern for me. It's a real concern for those people that I care about, that I know have been had crimes perpetrated against them, sexual crimes, assault, and we're now going to help them get away with that crime. Because when they go back, they're not going to be sentenced to anything. So if it's to get the criminals, then we need to get the criminals. We don't need to just send somebody back with no operator's license because they're here. So I'm really concerned, and I'll be in that vote.
For purposes, gentleman from Columbus, Representative Jones Ryan. You have the floor to make the motion.
Thank you, Madam Speaker. I hope this statement will help clear up some things for you folks. This bill applies to illegal immigrants in the custody of officers charged with a crime. I have heard that rabbit case on the other side, so that rabbit is dead about things that this bill has nothing to do with. This is requiring sheriffs who took an oath to do their job. If it was a bad idea when we were a committee, we'd have had 95 sheriffs in there, not 4. The sheriffs agree that it's a good idea. The Sheriff's Association agrees that it's a good idea. If it's good enough for the citizen of North Carolina to have to uphold these laws, it should be good enough for one that could possibly have a detainer on it. These are criminals. This is not targeting anybody. This is about someone who has been arrested that is a criminal. I have some great guys on this bill. Great legal mind, if you agree with it or not, great legal mind. Former sheriff, senior member, and I'm just a citizen. But a concern. By putting my name on this bill, and hopefully getting into the law, that it keeps one person from being assaulted again, one person from maybe being murdered, or one person from being raped because we inconvenienced a criminal for 48 hours, I'll take that.
Members, I show only one speaker remaining, and that intends to be the last person I call unless your lights come on down. For what purpose does the lady from Pitt, Representative Smith, rise? Passes on. For what purpose does the lady from Durham, Representative Moore, rise?
Thank you, Dennis. Representative Hastings, a question?
Representative,
I'm sorry, Representative Jones.
Representative Jones, you yield for question.
Listening to your remarks just now, do you really believe all people in jail are criminals?
Not my fault.
Well, you may respond to the question.
I do not believe that everyone in jail is a criminal. Just like I don't believe everybody in the store is a shoplifter. But I also heard in this chamber just a little while ago that we want to say that crimes, some of them are not really crimes. We shouldn't punish people for certain crimes, and that's disturbing to me.
The lady,
I'd like to speak briefly.
second time, you have floor to speak second time. This will be the one after this final speaker.
Thank you. Members, I stand because many of the remarks are saying people in jail are criminals. And we're talking about constitutional rights. Don't forget, there's a presumption of innocence until someone is convicted of a crime and maybe given a prison sentence. But to keep referring to people in jail as criminals is against every fiber of what we believe in the presumption of innocence, and I hope you remember that. Thank you.
gentleman from Cleveland, Speaker Moore, is recognized to be our final speaker.
Hey, Madam Speaker, just a few remarks about this bill. This is, and again, I don't debate often, but this is one that I debated when we took it up before in the House, and that I feel compelled to speak to today. I just happened to be in Charlotte the other day when the news came out about the fellow being released who had been accused with rape, and apparently had a long criminal history. And I was just shocked by it. And then I've had some to say, well, why do you worry about what happens in another county? Well, because, for example, Mecklenburg County is our largest county in the state. Many people in my district work in Mecklenburg County. I'm there all the time. I was there representing a client that day. And it is, in these large counties of our state, just I think now 5 counties, to have sheriffs who think that it is a good policy for some political reason to release dangerous criminals on the street, to let folks who are accused of rape. It's more serious than a parking ticket. I mean, these folks accused of rape, other serious crimes, to release them out and not honor those ICE containers does not make sense. And there comes a time when even someone who's politically elected, like these sheriffs, should be able to put aside politics and do what's right for the public's safety. And as I've sat down and tried to rationalize, it doesn't make sense. I mean, my 2 teenage sons looked at it and thought, that doesn't make any sense. I have yet to run into anybody that I'm talking to on the street or back home that thinks that that's a good idea to release someone accused of rape and not turn them over to Immigration's Custom Enforcement officials when there's a detainer. So what is a detainer? So a detainer does not apply to simply anyone who is here under illegal or questionable immigration status. A detainer is issued by ICE when it is someone who is in custody for a crime and they have probable cause to believe this person is dangerous, that they have committed other crimes or shown a propensity to commit crimes to be dangerous. Now, we've seen examples of where gang members have come across the border and committed all sorts of crimes. That's where a lot of this got started at some point. But then the realization that making sure that if there's someone here illegally who is in custody and has committed a crime, that they should be held until they can be turned over to ICE officials. Now, there is a separate process that goes through to ensure that their rights are safeguarded. So, as an attorney, absolutely, everyone who is taken into custody by the government is entitled to rights. They're entitled to rights to counsel. They're entitled to other constitutional rights that anyone should have if they're taken into custody. Our government must always be checked on them. But this is a common sense provision, allows 48 hours. You can look at a couple of the judges who've spoken. We can name several examples of where individuals under our state courts, people who are citizens, can be held for up to 48 hours without a bond being set. Look at Chapter 50B. There are several examples of that. So 48 hours has been recognized by the courts as not too unreasonable of a burden to give time for law enforcement to execute the process, to take that person to custody, to then get that individual before whatever the next level is. If they're taken into federal custody, to go before a federal magistrate, to go before the immigration court. But as a state that wants to uphold laws, that wants to protect our citizens, it only makes sense. Now, I mentioned those who said they were concerned about victims of crime. I do think we need to make sure that someone who is here, regardless of their immigration status, should feel comfortable reporting to law enforcement if they're a victim of crime. Absolutely. But some of these individuals who've been taken into custody, some of these individuals who've been turned loose by some of these sheriffs, have committed crimes against members of that very population. They've committed crimes against other individuals who maybe they shouldn't be here legally, but guess what? They deserve the rights and protection of laws as well. And they deserve to know that someone who has hurt them, who has injured them, someone who has tried to rape them, is not just going to be turned loose back out on the street. And I want to represent back up what Representative Smith said. Look, if we've got a situation where folks think it's okay to release somebody charged with a violent rape back on the street, we've got even bigger problems. That shouldn't be happening. That should not be happening. So this bill strikes a balance. It strikes a balance between protecting the presumption of innocence
guaranteeing that someone can get in front of a judicial official for a hearing without unnecessary delay, and at the same time ensuring that someone who is here illegally and is dangerous and is being held for a criminal offense can be reported to the proper immigrations and customs enforcement to be turned over to ensure that everyone is protected. My friends, that is all this bill does. It is not a broader debate on immigration. That is a federal issue. It's not a debate on other matters. It's simply a debate on whether you believe that you, your friends, your neighbors, and that every citizen and every person in this state, regardless of their citizenship, deserves to be protected from violence being committed against them. This is a good common sense bill. I hope you'll support it.
For what purpose the gentleman from Wake seek recognition?
Ask Speaker Moore a question.
Speaker Moore, you yield for a question.
Yes.
Mr. Speaker, with all due respect, you said it twice in your comments about these detainers and only for violent criminals. But wouldn't it in fact correct that in March of 2017, ICE changed their detainer forms? They moved from form number 274 to 278, and no longer is criminal record or danger to society or any of those other things it required for an ICE detainer, and now the only thing is required is a final order of removal?
I think if you'll look at the information that ICE has put out, they very clearly said they are looking at folks who are here who have committed crimes and who pose a danger. In fact, the situation in Charlotte just the other day, the U.S. Attorney's Office and ICE released a statement talking about how this was an example of a violent person being turned back out on the street. But they don't have the resources to be out trying to enforce all of this. If you look at the individuals where this has been an issue, it's been where folks have been arrested, charged with a crime, not just a traffic ticket. You and I both know as attorneys, someone goes out and commits a motor vehicle offense, unless it's a DWI or something, generally they're going to get a ticket, they're going to get criminal summons, they're going to go on their way. These are for serious offenses where they're actually being taken into custody, processed, and being assigned either some kind of bond in that case. And in those cases, all this bill says is that sheriffs are subject to removal if they refuse to cooperate with ICE when there's an ICE detainment. So let's look at the practical application. The person's coming in. If they're coming in on some minor little misdemeanor, they're going to go in front of a magistrate, probably get some small bond and go out the door. There's not even going to be ICE involvement. ICE involvement comes when it's a serious crime. Domestic violence, sexual assault, child abuse, robbery with a dangerous weapon. Go on and on and on those things where someone actually has to post a secured bond, is taken into custody, and then activates the process where ICE is activated. So let's don't fool ourselves. I don't care what the form says. Look at the application of what happens. That's exactly how that happens. And I think as a fellow attorney, you would have to acknowledge that's generally how that works. Folks are being held in those kind of cases with secured bonds that were triggered on serious offenses.
Question for the House. Mr. Pastor, please, the motion to concur in House Bill 370 conference report. Those in favor will vote aye. Those opposed will vote no, or what to vote. Representative Jarvis, does the manager's report? Clerk will offer the record to vote. 62 having voted in the affirmative, 53 in the negative. The motion to concur passes and will be engrossed and sent to the governor by special messenger. Senate Bill 559, the purple read.